Good morning,
Your
Counsel.
Honor. Good morning, Your Honors. Attorney David Mirsky for 2 Trinh. I have 3 issues in my brief. I would like to address issue number 3 first, the closing argument issue. Your Honors, what happened here is that there was some doubt raised about identification at trial, particularly by one Commonwealth witness, Xiao Tong, who specifically said he wasn't sure that the defendant was the person who did the acts that are alleged as the crime in this case. And to address that, the prosecutor, faced with a competent, qualified, exemplary defense attorney, sought to essentially discredit the whole practice of representing a defendant at a criminal trial, and also to essentially indicating to the jury personal knowledge of what actually happened and which witnesses were telling the truth, and specifically saying that some of them were telling the truth. I have 8 instances here. If I may, I would like to go through them, but I'd also like to point out that the trial judge there were objections. The trial judge let this go on, and Commonwealth versus Williams, the trial judge in that case stopped the prosecutor. In this case, did not stop the prosecutor, and the argument was overwhelming. It was really an attempt to basically cover what was a problem with evidence with argument, and also what was a problem with having, it's on the record the defense attorney is Rosemary Scapiccio. Her qualifications are known. Why is she a good lawyer? She does what a lawyer is supposed to do. She does her job.
Why isn't it fair game if the defense has been, part of the defense is attacking the police and the police investigation? Why isn't it fair game for the prosecutor to say the defense is saying this is all the fault of the police and that's not fair? I mean,
well, first of all, the police in this case didn't interview the people in the house. They didn't interview all the people in the house.
Okay,
they didn't bother to pursue the beating of one of the individuals. They didn't question and pursue that. There were 3 different ballistics types found on the scene. That they're not all accounted for by what was presented. And what the prosecutor said was specifically, and also it's public knowledge that Rosemary Scapiccio has uncovered what has been found in court to be improper conduct by police in the Boston Police Department. And the prosecutor said, to come in here and point the finger at the Boston Police Department because it's easy to do is just not fair and it's not right. Well, that's the defense attorney's job. If she was just doing, she was doing her job.
Did the judge tell the jury what the prosecutor really meant? Didn't the judge give an instruction to say that?
The judge, that's the problem, Your Honor. The judge tried to slough it off, in my opinion. By saying that this is what the person really meant, instead of saying this is improper, and that's what Commonwealth versus Williams indicates should be done in order to cure the prejudice.
And in terms of the jury's evaluation of the evidence, does it matter? I know you would prefer the judge to criticize the prosecutor, but when the judge says it's perfectly appropriate for an attorney to do what she did, and the prosecutor's word should be interpreted to mean that, not to infer that she's not properly doing her job. Why is that not sufficient?
It's not just what I prefer, Your Honor. Actually, this was I'll go through the 8 instances. This was an argument that was not stopped.
Before you do that, when the judge said that the prosecutor meant to say a certain thing, was there an objection to that comment by the judge?
No, Your Honor. How many times is defense counsel supposed to object? I mean,
Well,
she
I mean,
objected during the argument, and that was overruled.
Aren't we to infer then that the absence of an objection, shouldn't we not infer that the defendant was satisfied with the judge's curative instruction?
No, Your Honor. I think that what we should know from what the defendant's point of view was that he objected at the time the argument was made, and the judge overruled it. And, you know, how much preservation needs to be done?
Well, I mean, the instruction, the judge says, what Mr. Lee meant to say was that it was unwarranted. Certainly, Ms. Capiccio has every right as a criminal defense attorney to under duress and attack against a party or individual in the case as she sees fit. What Mr. Lee meant to say, that it was, in his view, based on the state of the evidence and the circumstances of this case, that it was unwarranted, not that it was right or unfair.
Well, Your Honor, this is only what we're talking about is one of the things that was said, and this is not isolated. The instances were, if I may, first, you didn't hear one question about what happened that night on the street. And then the second
What's wrong with that?
Because defense counsel's not required and defendant's not required to present any evidence.
But it's argument.
If I may, Your Honor, these need to be seen in a whole. It's like kids dancing around a fire. They don't want to get too close. She wouldn't have been able to question a single one of these witnesses because they saw what they saw, implying that the prosecutor knows what they saw, and that's why we're there.
But isn't the focus of that part of the closing that the defense was trying to argue mistakes that may or may not have occurred in the police investigation, and it was distracting the jury from the actual shooting itself? And the prosecutor was trying to focus on the identification issue.
Well, Your Honor, I think the defense attorney was trying to focus on the fact that you're trying to identify a person who's arrested coming in from a foreign country, and there's questions of witnesses at trial, of the prosecution's own witness as to identity. And the quality of the investigation is important to all of whether we have the right person here. It's important to the jury. And I'll just continue. Defense counsel only discussed lighting once. I mean, that's also implying defense attorney defendant has to present evidence. Defense counsel didn't talk about their motive to lie, the witnesses. The one thing that...
Wait a minute, but I'm trying to understand why it's an argument that the defense had to present evidence. The defendant said only mentioned the lighting conditions once. That's a pretty good tactical move on the part of the defendant. You know, I acknowledge that there was lighting, only mentioned it once, and then kind of sloughed it off, whereas the prosecutor is trying to say, no, there was artificial lighting there, and they were able to see who did the shooting.
Your Honor, that we can sit here and parse out that part of and look at it in isolation, but this prosecutor said...
But isn't that what you're doing?
But no, I'm not, because this prosecutor said, I'm not up here trying to get over on you, okay?
Sorry, which means what?
Which means I'm not up here trying to pull the wool over your eyes like defense counsel is. I'm telling you the truth. That's what it means. And then he says about the main witness that the Commonwealth relied upon, Tuan Dow. With all due respect, the man was honest, but he couldn't organize a trip to the bathroom. Okay, that's not in evidence. Okay.
That he couldn't organize a trip to the bathroom?
Yes. And in other words, he's not orchestrating or
wasn't that just a way, perhaps inarticulate, but a way to say this was not a witness who was as organized as you might have.
Your Honor, this argument, we had a very clever argument by prosecutor trying to deal with why Xiao Tung said, I'm not sure this is the guy. And if you look at what he said, he was very clever about that. And that's permissible. But what we're talking about is extra information here, extra evidence. And that's...
I assume you're not claiming that the jury understood the prosecutor to say that he had personal knowledge of his inability to organize bathroom trips. I assume it was understood by the jury to mean he's not smart enough to produce a concocted story.
No, Your Honor. What he's saying is the man was honest. That's the point. That's the whole point.
But it was based upon points in the evidence. He was asking the jury to conclude that this man gave you an honest account of what he saw.
He's telling you, I know this man is honest. I'm
Well, he
not
didn't
up
say
here
it that-
trying to
he
get
didn't
over
say it
on
that
you.
way.
I'm not up here trying to get over on you. Hey, that's colloquial. That's me to you, me to the jury. You know what? I'm not up here to get over on you. I'm telling you what happened.
Well, didn't the judge give the instruction to the jury that what the lawyers say in final argument is not evidence, and that?
Yes, Your Honor, and that's why I point to Commonwealth versus Williams, which indicates that this type of argument, with this type of pattern of violation, that's not sufficient.
And didn't the judge tell the jury right after the prosecutor's closing argument that the prosecutor really has no way of knowing whether or not anybody is telling the truth?
Your Honor, he
He did say that, or she did. The judge did give that instruction right after the closing argument.
I don't think right after is pertinent because these were objected to, and the judge let this continue. So it was already known to the jury that perhaps this was okay. This was all right.
And the last thing the
And he
jury
said
heard.
Mr. Lee made a reference to one of the witnesses, in this case Mr. Dow, and he referred to him as honest. Mr. Lee nor any attorney can never comment on the credibility of a witness. Mr. Lee doesn't know whether or not Mr. Dow is telling the truth or not. So we cannot refer to him as honest or not, or vouch for his credibility or his honesty. That seems to be a pretty tough curative instruction.
It's not. What I'm saying is that you have to balance the amount of what needs to be cured, and if you look at Williams, and the fact that this was allowed to continue, and the types of things that were said, and the combination of vouching and giving personal knowledge, that's not sufficient. And when we're told all the time in all the cases, an argument shouldn't be reversed. A case shouldn't be reversed on an argument because there was no objection. But there was objection. Okay, and the point of that is that you stop counsel and you don't let the jury hear that. We're dealing with the reality. The jury heard all that, and they heard the prosecutor presenting himself as a guy that knows.
Now, let me ask you, if the judge had given precisely the same instruction at the time the objection was made, would you have been satisfied?
I would have been satisfied if the judge stopped the argument, said, this is improper. They're not supposed to say that. You're supposed to focus on the evidence. Counsel can't do that.
So your objection here is that she waited a few minutes too long.
No, it's actually the whole total of it, Your Honor. In other words, all of the series of statements, the combination, the fact that there's a eyewitness who's not sure this is the person that did it, and looking at the total picture.
Did the defendant or did defense counsel ask the judge when she was making these statements at the conclusion of the prosecutor's closing? The defense counsel asked the judge to say anything else?
I don't think so, Your Honor. I think that, there was a discussion about, I think there was objection, and she made objection. But what I'm saying is that it needed to be stopped at the time it was being done. Second of all, it was so extreme that it wasn't enough. It needed to be explicit that this was misconduct. It drew the jury away from the evidence, and also the evidence, the case was not strong. There was an eyewitness who wasn't sure, and it said so. And as I said, it's perfectly acceptable for a prosecutor to talk about that, which he did, tried to say, justify that and say, and somehow that the fact that he wasn't sure is a sign of honesty. But it's reasonable doubt, Your Honor, and that makes it not a strong case. I'd like to just go on, if I may, to the argument about the first argument, which was about the consciousness of guilt instruction. And I just want to point out that as the defense counsel stated, there wasn't really evidence that this person that is called Mr. Tu, the person living downstairs from Xian Nguyen, what that person even knew about the police. The testimony is...
Well, you do have an extraordinary coincidence of timing.
Well,
There's the shooting, and then there's the car, which doesn't move, and then suddenly he's gone for 5 years, as is his girlfriend and I guess the child, and all the stuff is left in the house. Now that you can argue that. I mean, can't you infer that something extraordinary happened, which caused him to take flight?
Your Honor, I'm pointing to the case Commonwealth versus Stuckich, 450 Mass 449, and the site at 453, where a defendant left the state and didn't return a police call, and there was not evidence that the defendant was informed he was a suspect or knew that he had a court date. And what we have for evidence in this case, first of all, remember, it is an identification case, so that makes what the judge said more important. What the evidence from Xian Nguyen is that sometime in January he rented out the first floor, and that in January, and this is January 2001, and that in January 2001 he was gone for 4 weeks, and when he came back, Mr. Tu wasn't there. And then also you should note that that this witness didn't identify the defendant as Mr. Tu in court. So what I'm saying is that when the judge said, taking all this into account, you have heard evidence suggesting that the defendant may have fled his home after he discovered that he was about to be arrested for the offense for which he was now on trial. I think that the judge's comment, he discovered he was about to be arrested, was not really in evidence.
And I gather there was no objection to that.
There was objection, Your Honor, to that whole instruction, and I believe that that this is the same as saying there should have been no consciousness of guilt instruction in the first place anyway. This is the same thing.
Well, you don't dispute that car was the defendant's car, do you?
Which car?
The Jeep.
The Jeep.
Well, we have evidence that's documentary, but we don't have, we have, that's one piece of evidence, that we have signatures, but we also have an eyewitness saying,
Well, weren't some of his
not identifying
possessions in the car?
Yes. I'm not saying that there's no evidence, but I'm saying that it's contradicted in a jury's mind by not identifying this guy in court.
Well, wait. There's no visual identification, but somebody at the scene of the crime got 4 numbers off of a license plate on a Jeep that the defendant got into. The Jeep was registered to somebody with the same name as the defendant. This same Jeep was found outside this particular apartment containing information or items. They had the defendant's name on it. The landlord testified that the tenant, even though he didn't visually identify him, it was Trinh. Isn't that at least enough evidence to get the question to the jury?
Well,
who can argue it?
There's another way of looking at that evidence about the license plate.
There's another way of looking at it, but is it absolutely unreasonable to look at it the way the Commonwealth was asking to look at it, to the point that it should not have been admitted?
Or the instruction shouldn't have been
Well, we're talking about the
given.
evidence that the instruction is based on is whether he left his apartment and cleared out of the apartment.
Yeah.
We don't have, like I said, as in Stuckich, we don't have this
the facts
person's...
are very different from Stuckich, I think. I mean, there were affirmative, independent reasons why that person was in Minnesota or wherever it was. I mean, it had nothing to do with anything, and you don't have any of that here.
Well, we don't have Mr. The defendant knowing anything about the police being there. We just have this guy rented an apartment in January, and then he came back 4 weeks later, and they weren't there. I mean, that's what the evidence is. And so the judge's instruction is a lot extra information not given in the evidence. And I'd like to
Now you have 8 seconds left.
Okay, I just would like to say, look at Commonwealth versus Walden, that the issue is whether the evidence warrants a reasonable doubt on malice.
Thank you, Counsel.
Thank you, Your Honors.
Morning, Your Honors. May it please the Court, Zach Hillman on behalf of the Commonwealth. With me today is ADA Mark Lee, who is the trial prosecutor in this case. We're asked this Court to affirm the defendant's convictions. There's a couple points I'd like to make right off the bat with respect to the prosecutor's closing argument. First, his argument spanned 23 pages in the transcript. The great majority of his argument was spent talking about the identifications made by the two eyewitnesses at the scene and tying all of the corroborating evidence with the eyewitness's testimony that this was the defendant who shot the victim in this case. Where the prosecutor does reference the defense counsel's closing argument, I think it has to be viewed in context. And defense counsel spent the great majority of her argument, actually the majority of her argument, talking on 2 principal areas. First, police investigation, particularly the lead detective in the case, and secondly, the credibility of Tuan Dao, who was one of the eyewitnesses. Against this backdrop, the prosecutor was certainly entitled to make reference to defense counsel's closing argument, particularly in those events or those instances where she didn't touch upon any of the evidence the Commonwealth put in that corroborated the eyewitnesses. It's perfectly permissible for a prosecutor to point to the jury and tell them that defense counsel is attempting to divert their attention from strong evidence at trial, which is what we had here. Now, his reference to the defense counsel's closing argument with respect to the investigation, likewise, was an attempt to highlight to the jury that the defense counsel was, again, trying to divert their attention from strong evidence of guilt in this case. He wasn't saying that it was unfair or defense counsel shouldn't have been pointing the finger at the police because it was the wrong thing to do. He was saying that her argument was unwarranted based on the evidence. He goes through in his closing argument and he says, the lead investigator did what he was supposed to do. He got to the scene, he assessed the situation, he delegated responsibility, they followed the evidence. He points to that, says defense counsel's argument was unwarranted, and again, she was using that as an attempt to divert the jury's attention from strong evidence of guilt. Nothing wrong with the prosecutor's argument in this regard. With respect to prosecutor's argument and Tuan Dao's credibility, again, he goes through his entire closing argument and points out every bit of evidence that corroborated Tuan Dao's eyewitness identification of the defendant. He argues that he's a credible witness based on the evidence that supported his testimony. And again, he points to the witness's demeanor on the stand and says to the jury, look at this witness. He possibly couldn't have made this story up. He just didn't have it in him. Again, arguing based on the witness's demeanor, proper argument, entirely proper argument.
Is it proper to call somebody honest?
It is, Your Honor, as long as it's based on the evidence. And here, again, the prosecutor says to the jury, Tuan Dao was a credible witness based on each piece of evidence that corroborated his testimony, from the ballistics evidence to the leather jacket that was found to, again, Chow Tong's testimony that corroborated. So, yes, I believe certainly when there's evidence that would corroborate and supports an argument that a witness is credible, certainly permissible argument.
Of course, the interesting point, though, is that when it comes to the question of identification, honesty really isn't the test. It's accuracy. You could be honest and mistaken, and that can be devastating.
Well, I would. You're right. I mean, but I think that's what the prosecutor was arguing here. Not that he was an honest witness, but that his identification was accurate. And the prosecutor says right off the bat, this is a case of identification and whether or not the identification was accurate. And then he goes through each bit of evidence that corroborated the eyewitness identification.
Is this the witness who actually knew the defendant, though perhaps not by name?
This was, yes. This is Tuan Dao, correct.
What about when the prosecutor says, I'm not trying to get over on you, and your brother suggests that the unspoken is unlike the defense attorney.
I would suggest to the court there's no improper argument or there's no impropriety in that argument. He's not conveying to the jury that he knows something about the case that the defense attorney does or she's hiding from the jury. He's simply saying she's diverting your attention from the strong evidence in this case, and that's permissible argument.
But isn't it somewhat disparaging, though, to say that? To say it that way?
I don't believe so, Your Honor. Again, I think you have to look at it in the context of the entire argument, where defense counsel spent her entire argument disparaging the Commonwealth's case and the lead investigator in the police investigation. I think prosecutor's argument here was certainly a proper response to defense counsel's argument. And certainly while the argument was proper, the judge here instructed the jury, gave prompt curative instructions for just lest there be any mistaking or any confusion with respect to the prosecutor's argument to the jury. Now, with the consciousness, I'd like to move to consciousness.
Yes, I wanted to ask you about the consciousness of guilt. Mr. Ruski says there was basically no evidence that the defendant knew or might have known that he was about to be arrested, that the judge, in substance, added that in. Was there evidence?
Well,
what was the evidence with respect to that was the basis of the consciousness of guilt? Was it, as the defense counsel just said, the fact that the person that rented the room came back a month later and then he wasn't there, or was there more?
No, I think there is certainly more. The defendant's landlord testified that he had come back a few days prior to Chinese New Year, which was the day that the murder took place. When he came back, he never saw that defendant ever again. Just left lock, stock, and barrel, left all of his possessions in the apartment, and defendant and I believe it was his wife or girlfriend and daughter picked up and left. The police.
Sometime between January 20th and whenever he came back, which was when?
Well, I'm sorry. When the defendant came back or the landlord?
The landlord.
He came back, I think he said, a couple days before the Chinese New Year.
Right, but then I take it he must have come back after that, which is when he saw the stuff there. So
Right.
Was that about a month later?
No, it was a couple days prior to the murder. Is when the landlord came back from Vietnam. He went on a 4-week trip to Vietnam. He testified he came back just a few days before the Chinese New Year, and when he got back, he never saw the defendant again. And remember that this murder took place on the Chinese New Year. We have witnesses who put the defendant at the scene. We have the witnesses who put the defendant in a black Jeep bearing license plate 6639. That Jeep was found outside of the defendant's residence within a day and a half of the murder. That Jeep was surveilled for a week. No one got in, no one got out, no one moved the Jeep. Once the warrant issued for the defendant's arrest, he was nowhere to be found.
When was the warrant in relation to I think the date was January 23rd. When was the warrant in relation to that date?
March 9th.
Is it your view that to get a consciousness of guilt instruction, the prosecution must show that the defense knew that he was under investigation, or is it sufficient that the defendant knew that he had just committed a major crime worthy of intense police investigation?
The latter, certainly the latter, Your Honor.
But
I think
it's what the
Commonwealth
judge said. It's that the problem is what the judge said.
Well, okay, right. And I would point out, first of all, that this instruction is viewed under substantial likelihood standard. The defendant objected to the giving of the instruction prior to the judge's instructions during the charge conference. Immediately following the instructions, she declares herself content, except for the objections she made prior to. She couldn't have objected to the substance prior to the instruction, simply because she hadn't heard it yet. So I would suggest to the court this is viewed under substantial likelihood standard. Now, it's true the judge made a slight misstatement when she told the jury right at the beginning of her consciousness of guilt instruction that they heard evidence the defendant may have fled because he learned he was about to be arrested. I would suggest, however, that the defendant suffered no prejudice from that. In fact, I would suggest to the court that it was actually benefit. I think a jury could reasonably infer that someone who leaves immediately following commission of an offense or a commission of a crime is the more culpable, as opposed to someone who waits to find out if they're going to be arrested or if going to be indicted. The jury's attention wasn't drawn to that point with the judge's instruction, and in all other respects, the judge's instruction replied with each and every Tony requirement as set forth by this court. I would suggest to the court the defendant suffered no substantial risk. The judge's instruction was entirely proper except for that one misstatement, and defendant couldn't have suffered any prejudice.
With respect to the manslaughter instruction, Mr. Mirsky mentioned evidence of, I think, 3 separate kinds of guns at the scene. There was a spent .22 caliber casing near the victim, and the defendant was killed with a .38 caliber. What was the third gun?
The defendant, I'm sorry, did you say 38 or 380? The defendant was killed with a .380.
Okay.
The .38 was dropped by Quang Lai after he, I think, once the partygoers came out of the house and started to fight with Quang Lai. That was found underneath a red car,
All right.
right in front of 41 Kimball Street. The .22 shell, my brother suggests that the .22 shell could be evidence that the defendant was engaged in some sort of firefight and feared for his life. That argument is based on nothing but speculation. In fact, there's no evidence that that shell came from anybody or any partygoer at that party, particularly the defendant. Every witness who testified consistently and continuously that the defendant had nothing in his hands as he approached the victim had nothing in his hands as he approached the defendant. In fact, his hands were out, and he was simply asking him questions. The only reasonable inference that can be drawn as to where that .22 shell did come from was the driver of the getaway car. Chow Tong testified that as they tried to prevent the defendant's friend, Quang Lai, from getting into the car, the driver reached back and he heard with a firearm, and he heard one shot. This was right in the area where Sin Tran was killed and right in the area where they would have been struggling to keep Quang Lai out of the Jeep. As far as the judge's decision to not give a manslaughter instruction, the only evidence was that the victim exchanged words with the defendant, and that certainly is insufficient to support a manslaughter instruction. Unless there are any further questions, I'll allow my brief.
Thank you, Counsel.
Thank you.